from the studios on the Daytona Beach Community College East Campus.
Oh, Business Hotline. I'm your host, Ned Harper, and tonight's show is on patents, trademarks, and copyrights. How do you protect and make money with your ideas? The Small Business Development Centers throughout Florida help clients get information necessary to enjoy business success. Tonight, we have a successful inventor and an attorney experienced in intellectual property law that will share how we keep control and profit from our creations. Heather Vargas, copyright trademark attorney with Cobb Cole.
Hi, thank you.
And James Cairns, author of The Inventor's Pathfinder and co-founder of Ocean Design.
Thank you, Ned.
This is a live call-in show, so call 1-800-901-9238 for answers to your questions about patents, trademarks, and copyrights. Dr. Cairns, what advice would you give an inventor on getting started?
Well, it's a great question because, as you know, almost everybody at one time or another has what they think is a good idea for an invention, but they don't know what to do next. And many people make the mistake of rushing to a patent attorney and filing a patent, which is not the right thing to do. So I recommend that the one starts out by trying to advance their concept as far as they can within their mind's eye. Just bear down, focus on it, think about it, simplify it, refine it, and get as far as you can like that. And then the next step, also which I recommend, is to try to make some simple prototypes that allow you to test out the basic concepts that are involved in your patent. I mean, maybe it has one concept, might have two or three that interact. Try to just prove out that those work. And doing it with your own hands is a great experience because as you do, you'll see ways that you would have done it better or differently. As you go through this, you should keep a bound and dated journal to write down everything you do so you'll remember it. That's my problem. And also it can be valuable later to establish dates and things perhaps to defend your patent. Now, once you've done that and you're pretty sure that you have a concept that works, I recommend then also preparing a very detailed presentation that you would give verbally to explain your idea to someone else. Then you don't necessarily want to actually explain it to another person, but if you have a trusted individual who won't steal your ideas, it's good to have somebody. Your mom would do. And stand at a blackboard or whiteboard and give your presentation, and you'll pretend there are people there being critical of you. Strange as that seems, something different happens when you're on your feet verbalizing your ideas than when you're sitting quietly at your desk. It puts a little extra pressure on your mind. Having gone through that, I would think the next step that one should do is to go online and do a patent search yourself. Now, if you want to be an inventor, an independent inventor, you've got to do a little homework. So you've got to learn a few things. And one of the most valuable things you can learn is how to research patents online. So do that. And you get into the patent databases, and I'll tell you later how to get into those. You'll see a lot of art that looks like what you're trying to invent. You learn from that. Take whatever ideas are there that are public ideas and incorporate them. Or you might see other directions that your invention can go, or you might see some that didn't make it to the marketplace. You could call those inventors, find out why it failed. So now you're getting quite along with the process and you've learned an awful lot. If you're convinced then you have a good idea, it's time probably to think about patenting it. But here again, I don't recommend going to an attorney and filing a regular patent. The United States Patent and Trademark Office offers the opportunity to file a provisional patent application. It's very low cost. It buys you limited but pretty good protection for 1 year, in which time you can put patent pending on your device. You, under cover of confidentiality, you can tell other people about it and let you go along with your program quite a ways and still abort if you have to at a certain point without losing much. So beyond that, then there are many other steps that follow, but this is usually gets you led into it, and keeps you on a fairly frugal path for the first year or so. And one thing I stress to beginning inventors is to do as much as you can yourself, be as frugal as you can, and expect to work awfully hard.
Great tips and good direction as far as getting started. We have a caller from Lake Helen that has a question. Caller, what is your question tonight?
My name's Jeff Davis. How are you all tonight?
Great.
Good.
Great. The question is this: I already have a patent on a circuit. I'm an electrical engineer. I have a patent on a circuit that gives you double the miles in some things like an electric golf cart, toy trains, flashlights, things like that. But I've had basically zero luck. I hired a marketing firm to market it for me and spent a lot of money on that, and they couldn't get anybody interested in it. And I know probably the big oil and battery companies are against it, but there must be somebody out there that's interested in something that gets that much better use out of ordinary batteries. And I'm just having like zero luck. I'm wondering what in the world can I do, or what is happening, or what can I do to break this deadlock?
Well, Jim, you have some suggestions on...
I have some suggestions. I mean, it's hard for me to know exactly what this inventor's circumstances are, but for beginning inventors, I think the best thing to do is to probably try to find someone to license your invention, license the rights to your patent. It would be like renting out your intellectual property. And in terms of finding out how to approach somebody for that license, there are a lot of ways to do this. Once again, I would say to go online and look for similar products, if there are any. Go to trade shows where they have golf carts or whatever your target market is, and talk to the people in the booths. You know, strangely enough, at trade shows you can get to company executives that you couldn't get to in any other
That's
venue.
true, yes.
So take whatever information you have and show it to them. That's probably the best suggestion. Now, going any further than that, like setting up your own shop to build them or something, I think is too huge of a step and too potentially risky for a beginning inventor. I hope that helps.
Do you cover in your book a little bit about getting your idea promoted and getting it licensed and all of that? Okay.
And one of the things I would say to this caller is that going directly to a marketing firm is probably a waste of money. In 99% of the cases, they'll take your money and you won't learn anything.
Okay. Well, Heather, we've been leaving you out of the conversation. I've heard talk about intellectual property. What is that?
Intellectual property is a term that we use to refer to 4 different methods of protection. There's the patent, which Dr. Kanj is 10 times more qualified to talk about than I ever will be. So that's for the protection of an idea. A copyright is for the protection of the expression of an idea. So that's a copyright, or that's a novel, or music, or software code. That's protected by copyright. Trademark is the protection of a brand. So that's when you want to protect the name of your business or the name of a product: Coke, Pepsi, Tide. And then trade secrets are for the protection of that which has value because your competitors don't know about it. There are a number of different types of things that qualify as trade secrets: your supplier list, your customer list, and then those ideas which haven't quite made it to the patent world yet. You are trying to keep very close to the vest, and you're keeping them a secret until such time as you make them public. Those would be trade secrets.
Well, I've heard artists say that once they've created something like a song or a picture, because they created it, they own it, that it is protected. Is that true?
That's exactly right. Copyright vests in the author at the time of creation. So once it's fixed in a tangible medium and it's substantially complete, the copyright is owned by the person who created it, assuming that they didn't create it in the course of employment, in which case it belongs to the employer. But copyright vests automatically.
So do I need to get a copyright if it's vested automatically?
Well, we do recommend registration in virtually all cases because you can't enforce your copyright through an infringement lawsuit until you have a registration. And if you don't have the registration within a very limited period of time after creation, you can lose the ability to gain certain damages in an infringement suit. Most importantly, of course, attorney's fees.
So you get a lot more protection. We have another caller from DeLand. What is your question tonight? Caller from DeLand? Are you there?
Yes.
What is your question?
My name is Frank, and I invented something, and I made that mistake that what you were talking about. I took off and went to see an attorney, and I'm at a point now, like, after he gave me all the figures that I'm going to need money-wise, it's like $10,000. So I want to know, is there a cheaper way that I can go that, money-wise?
Yes, there possibly is. First of all, let me say I'm pro-attorney. I think to do anything properly, you eventually need the attorneys. Absolutely.
I'm with you on that, but you have to do your work too.
But you have to
can't
do
expect them to do all your work for you.
Exactly so. So, and also I will say that $10,000 for a utility patent is not out of line. That's about what they cost. Take you a couple years maybe to get it. So, but there are intermediate steps that an inventor can take before going directly to filing a patent. And I discussed some of these, I think, for
you already did,
the previous
right,
caller. But just to
provisional
reiterate
patent
briefly, it would be to file a provisional patent, which you can do for hundreds of dollars, typically not thousands. And it gains you a year to advance your program.
Great, and you're going to give us some websites and some opportunities to get more information on.
I will. Let me mention one website
Okay.
now because it's something that everyone should know about who's interested in inventing, and it's www.uspto.gov. And that USPTO is the United States Patent and Trademark Office. It's their official site, and it's wonderful.
Talking about trademarks, how is a trademark protected?
Like a copyright, a trademark doesn't require registration. Trademark rights vest at the time that the mark is used in association with the sale of a product or service within the market in which it's used. So if you start a business and you're using your name, whatever it might be, in the Daytona Beach area, then you're protected within the Daytona Beach area. The benefit of a federal trademark registration is it gives you nationwide protection. So someone can't come to Daytona, find out about your business, think it's a great idea, love the name, and take it back to California or Georgia or Orlando and start a competing business.
Now, I heard you speak at a symposium about the protection and enforcement. Can it's protected federally,
Right.
but they're in Seattle, Washington, and I'm here. How about the enforcement?
Well, the enforcement of any of the things we're talking about, patents, copyrights, trademarks, unfortunately only comes through litigation. The only way to protect your rights, if you can't scare someone into stopping when they're infringing one of your intellectual property rights, is to sue them. And you typically have to go where they are to do that. Though we find, I would have to say, better than half the time, simply alerting someone to your trademark rights or your copyright or even your patent rights will put a stop
That's
to the
definitely
infringement.
true for patents as well, that in any of these things, to create a new marketable product, whatever it is, you spend a lot of money. And if there's this cloud of litigation on the horizon, most companies back away from that, as they should.
Because the intellectual property litigation is extremely expensive. A patent lawsuit can be a $3 to $5 million proposition. A trademark lawsuit is hundreds of thousands of dollars. So if someone hasn't yet invested substantially in the intellectual property, it's simply not worth it.
But in some cases, maybe a letter might be enough to let them know that they have crossed the bounds.
It very often is, particularly if you have registration for your patent or your trademark or your copyright.
For patents, I might add that I'm not sure it's true for copyrights, but it's also a very, very long process, years and years long. So it's a losing proposition to get into.
It's not quite as long for trademarks and copyrights as it is for patents. Patents are probably the most expensive and time-consuming type of litigation, bar none.
Well, you talked about the expense involved in it. Can you get financing for that? You said be frugal and bootstrap and don't waste your money. Can you get financing to?
Yeah, if you have a very good idea, there are a number of ways you can get financing. But if I can talk a little bit
Sure.
about this, one way is through the U.S. government, and they have the SBIR programs and STTR programs, which are programs funded by the government to try to stimulate the development of technology that's needed by the government. So if you get involved in those, you can get staged grants that will pay a salary to the inventor and his few employees to take that idea forward. So, and they're not very invasive in terms of what they take away from you.
Mm-hmm.
But if an inventor seeks outside private financing, then early in the game you're going to give up an awful lot both of control and ownership for what you get. And particularly you couldn't get financing for a litigation, I don't think, without losing substantial control. So I think that everybody, each inventor, should take the thing as far as he possibly can before seeking any outside financing.
And that raises an interesting point that I think is true with patents and also with trademarks and in some types of copyright, particularly in the software arena, and that is individual ownership of those properties is not necessarily the best path. If you create an entity, and it's a very simple and inexpensive thing to do, to create a limited liability company or an S corporation, then you're separating the liability, the potential liability associated with your intellectual property from your personal assets. So that if it turns out your trademark does infringe something owned by Coca-Cola and you get yourself in a lot of trouble, then it's the assets of the company that are at risk and not your personal assets. You don't come and take your dog.
You know, Heather, I mentioned the SBIR programs before. They also do not give money directly to individuals. You can be a single person corporation, but you have to have some sort of a legal entity other than yourself to receive such funds.
And I know we have an SBIR program here. The County Economic Development Department has one here, and I know in Orlando they have a real big research park, so there is opportunities with that. You talked about infringement. What does that mean?
Well, it depends on which arena we're talking about. But for example, in a trademark infringement, if you start using a name for a business and you haven't had it checked out first, it could be that there's a federal registration for the same name or a confusingly similar name, such that consumers think that you are in some way associated with the owner of the superior rights. That is what is the crux of trademark infringement. Copyright infringement is if someone rips off the lyrics to your song or steals your software code, or as the RIAA is fond of saying, pirates your music. Any time that you use a substantial portion of a prior existing copyrighted work, that is copyright infringement. And the standard for that is it substantially similar? If the average person looked at it side by side, would they say, you know what, that house plan does come from that house plan. They're related in some way.
Well, I want to ask you, Jim, a little bit about your book. And I'm not promoting your book except that I feel it's a good resource. And I know it's very difficult for inventors to know the steps. It's very complicated. In the book, how does this help someone in the Inventor's Pathfinder? How will that help me if I want to get going with my invention?
Well, thank you for that question. I'm not here to promote. I didn't write the book to make money, so I'm not promoting it necessarily either. But I've tried in there to summarize 40 years of successful and practical experience at developing innovations and making money from them. What the book does is, it's called a Pathfinder, and what it does is describe a path that the inventor and the invention need to follow in order to have a successful conclusion. In there I tried to alert the reader along the path to the certain pitfalls that and mistakes that most inventors or many inventors make. Try to lead them through that minefield, show them ways to save money and to achieve their goals at each step of the way. I also give advice in there on when is a good time to sell or take on partners or outside financing at different stages in the invention's development. And also, if one wants to go the whole route, how to start up a little company, what to be careful of, and how to get it on the market. So it's what I tried to do was summarize the whole inventing process, even from how to stimulate ideas to how to cash in on them. I hope it's been successful and helps a few people out.
Well,
That is a critically important book to have on the market. I'm not a patent attorney, and I get these questions at least once a week. And I am so happy to know about this book because I don't know the answers.
Yeah, there is no other book like it out there. There are books written by attorneys that talk about patents, but there's, I think, none that have been written by anybody that's been through the whole process. So.
And that's great. I mean, so we don't have to suffer the way you did. and I really like, I mean, a lot of people don't know. I mean, you were in the garage like a lot of other guys. I mean, you started there, and now there's a nice company employing 220 people here in Daytona Beach, or more or less. I don't know. That's
around 300 now.
Around 300. So I'm behind the time. And I like that. I mean, it's giving back to our community just because you were a curious guy that wanted to figure out how to solve a problem, right?
I have started other companies and other adventures with inventions, all of which started in my garage. Not always the same garage. It's a good place to start.
Let's say I want to get a copyright or trademark, and I know about you. What would be the process? How would you help me?
Typically, people just give me a call and we talk through what sort of issues they have. People are often confused. What's a trademark? What's a copyright? When do I need a patent? And so we just do a little trademark copyright 101 in the initial call so we can tease out precisely what it is that we're looking for. And then we get together and talk about whether registration is the right option depending on the timing. And of course, I'm always going to talk about entity selection because I think it's so critically important to separate the intellectual property asset from your personal assets.
Well, let me also ask you about work made for hire.
Work made for hire is a term that gets tossed around pretty loosely but has a very specific meaning under the Copyright Act. Work made for hire is a copyright term, and it means if the work is made as an employee and within the scope of your employment. If you are not an employee and acting within the scope of your employment, then your employer does not own it, does not own the copyrighted material, unless you have an agreement that outlines that it's a work made for hire, and it falls within one of 9 enumerated categories under the statute, which rarely ever apply unless you're in the movie industry. What is more often used is if you're working with someone, say for example you hire someone to do a website for your SBDC, and you want to make sure that you own it when it's over, then what you're looking for is copyright assignment. And that's actually a transfer because you're the person who creates it. They're the author, they've created it, and so the copyright automatically vests. And if you want to own it, then you have to get an assignment that transfers all of the rights. And that language is consistent across trademarks and patents as well.
I've heard some horror stories about people that have created great websites and they depend on it for their business.
And it walks away.
Yep.
I get that call about once a month.
Can you make it come back?
Depends.
But it's a lot better. It's like entity selection, and contracts and those type things. To get the advice up front, it's a lot cheaper, a lot easier, and a lot better than to go ask for help after you've dug the hole. And
yeah,
you forgot
I promise
to do
you
this.
it's less expensive
to
to talk to me before than after.
And a lot of people don't realize that. I agree with you. You want to do your due diligence. You want to do your work. Going to them and an attorney trying to understand what you're trying to do is just really a waste of their professional time. So if you get prepared, you do your work, then it's going to be, but you then, like you said, you do need to go see someone that is licensed like that, and that can help you make sure that you set it up right.
And I'd like to go back to something you said earlier. www.uspto.gov is also the trademark website, and it'll give you the ability to check and see if there's a federal registration for the exact mark you want to use.
Well, that's our time for tonight. I really appreciate it. I think it's just great information. The resources are available, so it doesn't have to be that difficult, and that's the whole purpose of this show, to let people know that if they need help, we're here to help them. Heather and Jim, thank you for joining our show and sharing resources for protecting intellectual property and profiting from ideas. If you were unable to get your questions answered on air, please email us at channel15@dbcc.edu. For business training or planning assistance, visit your local SBDC or floridasbdc.com. Thank you for watching, and we'll see you next week on the Small Business Hotline. Good night.